Today, I just want to give a guide on data protection compliance in Kenya. Essentially, just going to dive into privacy laws in Kenya and how that affects you, whether as an individual or as a business. If you're new here, my name is Brolin. I'm a lawyer practicing and based here in Nairobi, Kenya. Let's get straight into it. So prior to 2019, Kenya did not have a standalone data protection law. Essentially, that meant that the only thing that governed how data was handled in this country was the Constitution of Kenya 2010. And under the Constitution of Kenya 2010, we have Article 31, which speaks about everyone having the right to privacy. I'll just quickly read it out. Every person has a right to privacy, which includes the right not to have their person, home, or property searched, their possession seized, information relating to their family or private affairs unnecessarily required or revealed, or the privacy of their communication infringed. So prior to 2019, before the enactment of the Data Protection Act, this is the only provision that spoke elaborately about privacy of individuals within this country. So you'd find that because of this gap, there was a lot of misuse of data in the country. You'd get a lot of unsolicited marketing messages. You'd wake up one day and find your image had been used by an organization or a business without proper consent having been given. So because of all this public outcry, it necessitated the need for us to have a standalone data protection regulation in this country. And that's how the Data Protection Act 2019 came into being alongside the regulations formed thereunder. So it kicked off in 2019, and since then it has been overseeing the governance of data protection issues in this country. You might be wondering, what is data? Essentially, the Data Protection Act protects personal data. Personal data relates to data relating to an identifiable natural person. A natural person is essentially, simply put, is a human being. So the Data Protection Act does not apply to companies, but rather it applies to individuals, you and I. A lot of us who own businesses collect data. So you collected the data. Now what? I recently came across an interesting story where a travel firm had used a client's email address to send unsolicited marketing messages. And the client filed a complaint before the Office of the Data Protection Commissioner, complaining where the travel firm had used the client's email to send marketing messages. You might be wondering, but the client gave the travel firm its email address. Yes, it did, but that doesn't mean that if a client gives you their personal data, then you are at liberty to use it as you please. So email addresses are part of what the Data Protection Act considers as personal data. Other things are your name. Your name is considered personal data, email address, your phone number, and so on and so forth. All these are considered personal data. So they are protected under the Data Protection Act. So the moment you collect data as a business, you take on legal risk. And it also comes with legal responsibilities, such as declaring why you're collecting this data, getting clear and informed consent if you want to use it for marketing use, and as well as keeping the data safe and making sure it's not used for anything beyond its original purpose. So all data controllers and data processors in this country are required to register with the Office of the Data Protection Commissioner. The ODPC is essentially the regulator of all matters in regards to data protection and compliance in this country. A data controller is a person who determines the purpose and means of collecting personal data. A data processor, on the other hand, processes data on behalf of the data controller. The regulations require that if you're a business who has an annual turnover of over Kenya shillings 5 million and you employ over 10 employees, you are required to automatically register as a data controller or a data processor. But if you do not meet this threshold, then this requirement does not strictly apply to you. But the fact that it doesn't apply to you doesn't mean that you are not bound by the provision of the Data Protection Act. You're bound by it. It's just that you are not strictly bound to apply to be formally registered by the Office of the Data Protection Commissioner. However, there's a caveat to this. There are some entities or organizations which must mandatorily register as data controllers or data processors. Some of them, as provided in the regulations, include organizations or businesses in the health administration, and provision of patient care, hospitality industry firms, excluding tour guides, property management, excluding selling land, provision of financial services, telecommunication, network or service providers, businesses that are wholly or mainly in direct marketing, transport services firms, including online passenger hailing applications, and businesses that process genetic data, businesses that are in gambling, crime prevention and prosecution of offenders, and conversing of political support among the electorate. So these organizations or entities, those activities revolve around these industries that I've mentioned, are mandatorily required to register as a data controller or as a data processor. It doesn't matter whether they meet the threshold of annual turnover of over 5 million or 10 employees. They're mandatorily required to register. So back to the story of the travel firm and the issue of consent. What really went wrong there? So one thing you need to note that consent is not always required, but when it is, it must be very clear and purpose specific. Here's the travel firm. You must understand that the purpose for which it collected in this particular instance was to perform a contract. A client has come to you, they want to make a booking, they want to travel, let's say, to the coast and enjoy the holiday there. You obviously need their email address for you to be able to communicate with them and plan accordingly this trip for them. So in that instance, your collection of that personal data, which is the email address, is limited to performance of a contract. Is after the performance of that contract or after the holiday has ended, weeks or months down the line, you're not permitted to send marketing or promotional messages to this particular client just because they gave you your email address a few months back or a few weeks back for purposes of performing a contract which was to enable them to travel seamlessly. So the Data Protection Act requires that for you to use someone's data for marketing purposes, you must get a very clear consent from them. The consent must be very clear, the consent must be unambiguous, there should be no doubt in the client's mind that they are consenting to have their personal data used for marketing. And again, the legal obligation is on you as the business to keep a record of this consent. If you do not keep a record of this consent, and maybe the client agreed orally and then down the road, they change their mind and say, look, we never gave this consent, then you are going to be in problems if you don't have a record of the consent. So that is one thing. There are several lawful grounds for processing data in this country. I've already mentioned one, which is performance of a contract, which typically arises more often than not. A client comes to you, and because you render a service and they need to give you their personal data for you to be able to attend to them, then they share this data with you. For instance, the travel firm, a client comes to you, they give them their email address or their phone number. You need this information for you to be able to perform the contract between yourself and the client. So that will be a lawful basis, performance of a contract. If you want to go a step further and use this information for marketing purposes, then you must have another lawful basis, which is consent. And as already mentioned, consent must be very clear and ambiguous, and you must keep a record of this consent. Another lawful basis for processing someone's data could be a legal obligation. For instance, banks are legally required to keep certain data sets, such that if they flag anything to do with anti-money laundering, or if they flag any suspicious activity, and these activities go against anti-money laundering laws and regulations, then banks are required to report this suspicious activity to the relevant government body which regulates these banks. So in that case, they'll be processing this data on the basis of a legal obligation they have to submit this information to the relevant government bodies. Another basis for processing data is vital interest. This typically applies in the health industry. For instance, if, God forbid, you get involved in an accident, you're rushed to a hospital, you're in critical condition, the doctors need to act and save your life or undertake an emergency procedure to save your life. In such an instance, then strictly speaking, it will be very difficult to get your consent before they can undertake this life-saving procedure. Unless, of course, you have an next of kin around, then that is a different story. But if you're taken in for an emergency at a hospital and there's no next of kin and you're the only one and you're unconscious, then the hospital can proceed and process your data on the basis of safeguarding your vital interest, which is to keep you alive. Another basis is for public interest. I'm sure as you travel around Nairobi, you've seen so many traffic cameras which have been installed around. Essentially, these have been installed to safeguard public interest for the prevention of crimes and such like stuff. Another lawful basis for processing data is legitimate interest. Same example of a CCTV. Businesses normally install CCTV within their premises. For instance, if you walk to a bank, you will find that CCTV has been installed there. So clearly they're going to process your personal data, which is your image. They're going to process this data because they have to protect their legitimate business interest in this case, which is the security of their premises. Moving on to what your privacy policy should actually cover. So first of all, what is a privacy policy? A privacy policy is a document that businesses ought to have, which cover things like what sorts of data do they collect, how do they process this data, how do they store it, how do they retrieve it, how do they destroy it, and so on and so forth. So businesses are required to have privacy policies in place. A thing I've noticed in my practice is that many businesses just keep privacy policy as another legal checkbox, just something they need to tick off that they're legally compliant. You go to another website, download a privacy policy, and you don't even change a single word. You just throw it on your website without changing anything and adopting it as is. Do you know that privacy policy you've just downloaded is not applicable to Kenya? Let's say you downloaded it from a US-based organization, and it has been tailored specifically to the US market, which might be a whole lot different from Kenya. So privacy policies must be tailored to the specific needs of a particular organization. That is very critical. So what are some of the key things a privacy policy should clearly cover? Most obvious one is what personal data do you collect? You need to be very clear. For instance, if it's names, contact info, ID number, travel history, if you're a business firm, this needs to come out very clearly in your privacy policy. Number two, why are you collecting it? Yes, you're collecting this personal data, but why are you collecting it? Is it necessary? You need it for you to be able to perform a contract. So that needs to come out very clearly in the privacy policy. Then you must provide the legal basis. Which purpose, contract, whether it's to perform a contract, whether you have a consent, whether it's to perform a legal obligation, needs to come out very clearly in the privacy policy. Then you also need to come out very clearly in your privacy policy, who do you share it with? If you're going to share the same with third-party processors or transfer it outside the country, it needs to be explicitly mentioned in the privacy policy so that data subjects are well aware of how their data is going to be handled. Then it also needs to come out very clearly where the data is going to be stored and for how long. If you store it internally, make it very clear how you store it and how you safeguard the same. You also need to outline who has access to this personal data within your privacy policy. Another thing that it needs to come out clearly is just to reiterate that if the data is going to be transferred outside Kenya, then this also needs to be mentioned. It's good practice to actually mention the countries that this data is going to be transferred to. Make it very explicit. For instance, if it's going to be transferred to the US, say this data is going to be transferred to the US, it's going to be transferred to Germany, South Africa, Uganda, and so on and so forth. So what does practical compliance look like today? How do you ensure you stay compliant and you don't find yourself in a situation where you're before the Office of the Data Protection Commissioner because you have infringed on a data subject's privacy rights? So first things first, you need to have a very clear data map or on how data flows within your organization. You need to map out very clearly, what data am I collecting? Do I need to collect it? What is the lawful basis for collecting it? So you just need to sit down with your team and map this out very clearly. Discuss with the team very clearly what data you collect so that you can map it out very clearly. This information is going to be very useful in terms of enabling you comply fully with the privacy laws. So once you have the data mapped out clearly, then you can move to the next steps, which is now formulating a very clean and practical privacy policy. And a privacy policy that is tailored for you, and it is not a privacy policy that you've picked from another website maybe a UK-based organization or a US-based organization, you just downloaded their privacy policy and used. No, that is not how you need to come up with your privacy policies. Once you've mapped out your data flows, engage a lawyer and just instruct them to help you. And not just any lawyer, a lawyer who is well-versed with data protection laws and can help you use the data map that you've come up with to and reduce it into a very elaborate and comprehensive privacy policy that you can use within your organization. Then another way for practical compliance is ensuring that you have contracts with third-party processors. Remember, I already mentioned that we have data controllers and we have data processors. Data controllers determine the means and purpose for collecting data. Data processors, on the other hand, process data on behalf of the data controller. So if you have any data processors, you must make sure you have a data processor agreement with them. This data processor agreement is very important to protect you as a data controlling business, such that if the data processor misuses personal data that you gave them as a result of a contract between yourself and that data processor, at least you have a data processor agreement to protect you. And it also acts as a good deterrent. If a data processor knows that you have a data processor agreement in place, the chances of them misusing personal data that you share with them for them to process on your behalf is very limited. Another thing for practical compliance is ensuring staff awareness. You as management or you as the owner of the business might know the importance of privacy laws and ensuring that your client's data is well safeguarded. But does your staff have adequate training to know how to actually treat different data sets? This is very critical. It's very important that your staff is well apprised of data protection laws and how to handle different data sets. Another thing is to have a compliance contract. It is recommended under the data protection laws and regulations that organizations have a designated data protection officer. A data protection officer is someone employed by the organization just to take care of data protection needs of the company. If there are takedown requests from clients, a client reaches out and wants their data pulled down or they want access to their personal data, the same retrieved, deleted, then this data protection officer will be there to assist the organization comply accordingly. Other than that, they just ensure day-to-day compliance. Their work, they sleep, eat, and breathe data just to ensure that the organization does not fall on the wrong side of the law on matters data protection compliance. So bottom line, good data practices are very important for a business. Your client should not wonder how data is going to be used. In a similar way, your staff should be very clear on how personal data is supposed to be handled internally. Because if complaints land before the Office of the Data Protection Commissioner, they can impose fines of up to Kenya shillings 5 million. That's a lot of money, and that's just a single incident. Typically, they range from anything between 500,000 to 5 million, which is the maximum they can impose. So it depends on the severity of the breach. The more serious the breach, the higher the penalty that is going to be imposed on a particular organization for a particular breach. So it's very important to ensure that your organization stays compliant, and your team should not be guessing what data protection compliance mechanisms are allowed within your organization. So that is all on the guide to data protection compliance in Kenya. I hope you enjoyed this video. If you did, please don't forget to like and subscribe. If you have any questions or concerns, feel free to share your feedback in the comment section below. You can also drop me an email. My email is in the About section of my YouTube channel. And see you in the next one.